I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other freedom of information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to our instructor.
Hi, everybody. I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of NEFAC's ongoing series on public records laws. This session will focus on the appeals process in Massachusetts and what you can do to fight back when your records request is denied in the Bay State. And with us is John Albano, and John's a partner at Morgan Lewis, where his practice is focused on commercial, media, and appellate litigation, as well as representing newspapers, entertainment, and news broadcasters and publishers. So John, thank you so much for joining us today.
I'm glad to be here. The topic here was how to deal with problems, basically, with public records requests. And I kind of group the common problems into two categories. There are probably more, but the two I see the most are sometimes there's an agency or a municipality that just is overly aggressive on exemptions, that, oh, this document doesn't fall within the public records law. These people think everything's private, everything's a personnel record, or everything might prejudice an investigation. Those are kind of legal battles of, that end up, as we'll talk about, in front of the Supervisor of Records and sometimes in court. The second group of problems that I think maybe is even more problematic are the custodians that say it's too much. You asked for too much. It's too hard. It'll cost a fortune because what you've asked for has both public records and things that are statutorily private. So I got to have a lawyer go through it and separate it. And so I want to talk about at least an approach to trying to deal with those kinds of problems with public records requests. This really reminds me of, part of being on the litigation side of practicing law is you need to draft discovery requests in litigation. And so, you do that from the time you first start practicing law, if you're on the litigation side. And the kind of concerns I think are similar that lawyers have on discovery requests to what reporters have with public records requests, because you don't want to draft it in a way that you miss the important document, right? It's like, oh, and that's just what we do when we're drafting discovery requests. But the problem is, there's a lot of motion practice and litigation over this, is the receiving side says in litigations, sounds a lot like what the agency says, like, whoa, this is way too much. I can't, you're asking for too much. This is not properly phrased, or it'll take me years to do it. So I was going to show one example. There's, this could be a document request or a public records request, right? All documents relating to the fiscal 2022 budget, including without limitation all emails. Well, what happens in these cases often is some wise guy says, well, what does relating to mean? Yeah, I mean, every check we write relates to the budget, every invoice we receive. And what about the 2021 budget? That relates to the 2022 budget. And you want all emails from everybody? from when? From the beginning of time? And so I think just as with discovery requests, public records requests, it's sometimes worthwhile to just stop. I think it's always worthwhile to stop and say, can I, without risking missing something, can I get this another way? You know, it's really about saying, well, can I say all documents that you relied on in preparing the budget? Does that, am I going to miss anything key there? They're going to say, oh, all emails? We have to search all custodians, you know, custodians, everybody that's got an email. So, you know, maybe we can identify who the likely candidates are that we're most interested in and put a time frame so that we're able to you know, revise it to say all documents relied upon in preparing that year's budget, including all emails from X date to Y date to and from these people. At least you're kind of in the game then. It gives them, makes it harder for them to say, oh my God, how are we gonna deal with this? The other thing I'm a big proponent on, I know it's hard to do and it's not always time to do it and they're not always receptive to it, agencies and municipalities, but man, if you can get some kind of a dialogue going with the custodian, sometimes it's impossible, right? They don't want anything to do with you. But as we'll talk about, they have an obligation to try and cooperate to narrow requests, to make it easier to comply. And I think it's often wise for us to try and build that rapport. Again, I get it. There's sometimes there's no way, no how. And it's frustrating to deal with some of these people. But even closing the request with, please let me know if you have any questions and maybe a follow-up phone call. And just trying to work with them a little bit. I think it's just human nature. It's harder to say no to people who are talking to you and kind of, you know, working you a little, to be blunt about it, than it is to just say, oh, I got another email from this person. I'm just going to repeat what I said to the last requester and get it out the door. Okay, so you make the request. Maybe you do a little follow-up, a little schmoozing. What are you supposed to get by way of a response? How do you know if you're getting an inadequate response that gives you a right to get a little more aggressive about what you're entitled to? And, you know, everybody knows this, right? The public records law is better than it used to be, but it's tough. It's not perfect, that's for sure. It sounds great, right? Because the law says you're supposed to get within 10 business days of the request, either A, your documents, if the custodian has them, and if the fees are paid. Or within 10 days, you're supposed to get a response that says, no, we're not going to give it to you. So let's assume they say no. First of all, you're entitled to that response within 10 business days. So if there's no response, you got to go back and say, hey, it's been 10 business days. Can I get a response? And again, I think, I mean, I definitely know this doesn't work because I all the time, because I've been working a clerk schmoozing for about 3 weeks with no results whatsoever. So I know it doesn't always work, but sometimes it does. What should they say? What else should they say in that response? What they should tell you is they should, if they're withholding documents, that response is supposed to tell you, here's what we're withholding and why. And they're supposed to list the site, the exemption that they're relying on. That's key. You're entitled to know, are they saying it's private? Are they saying there's some statutory prohibitions? Sometimes there is, right? There's some, you all know that. There's some educational records that can't be given out. There's some medical records that have special statutory prohibitions. So they're supposed to tell you why. If they're saying it's just too burdensome, they're supposed to explain why. And again, that gives you a chance to get back with them and talk about, well, how about this? How about that? But they can't just say, you've asked for too much. They've got to explain to you. We looked, there's, 10,000 documents that arguably fall into this. We're just not going to be able to do it. That needs to be in the letter that you get within 10 days. Sometimes they don't have the records, right? They just say, sorry, we don't have that stuff. They're obligated then, if they know it's another agency. So if you ask, DDS and it's actually, DYS that has those records, they're supposed to tell you, we don't have those. You should, but you can try this other agency to get them. That's an obligation written clearly in the statute. They are also supposed to suggest any reasonable modification that could make them able to give you what you need. And again, this is an opportunity for interaction, but it's a statutory obligation. They are supposed to say, well, you asked for this, but I could give you this. Would that work? What else are you looking for? So the statute really anticipates a kind of back and forth here. You're also entitled to a good faith estimate of what it's going to cost. That will be very useful, because sometimes, as I'm sure some of you found, you get a request that's, you get a response within 10 days, but it's like, yeah, so it'll cost $3,500 to get you this. And it's just like, well, that's no good. But if they give you the estimate, that gives you a basis for pushing back and saying, well, wait a second, why is it going to take this long? How about doing this? How about doing that? And they are also supposed to tell you when a reasonable time is for them to get you these documents. Now here the statute is helpful, but it's harder to enforce. The statute reads great. The statute says they got to tell you a reasonable time frame when the documents will be produced, but no longer than 15 business days after the request, if it's a state agency, or 25 business days after the request, if it's a municipality. So, the statute's great. That's, they're supposed to do it as soon as they can. But if it's burdensome enough, then the statute says, okay, if it's burdensome, we'll let you go out to 15 days. If you're an agency, municipalities, you have fewer resources, so you get 25 days. And if they can't do that, they have only one other option, and for some reason, they often don't avail themselves of this. They can get a little bit more time if they go to the Supervisor of Records. Now, I've used that term. I assume most of you are familiar with this. So the Secretary of State's office has responsibility for the public records law. There's a unit within the Secretary of State's office that's the Supervisor of Records, and I say this in air quotes, an enforcement unit of the public records law. But an agency in a municipality can say, I'm at my 15 days, I'm at my 25 days, I need a little more. And the statute says, oh, okay, if the supervisor says you're entitled, then agencies can get another 20 days and municipalities can get another 30 days if they can demonstrate that they really need it. Now, let's talk about enforcement. One positive thing that gives them some incentive to respond is that if they don't give you that response within 10 days, they can't charge you fees. So there is a price they pay if they don't respond to you within those 10 business days. I do think, not to be cynical, but I do think sometimes that leads them to crank out a response that has a big fee estimate while they're figuring out what the hell they're going to do with this request. And they say, well, I did respond, so I can charge, I just can't charge that much. So, like I said, there's problems with enforcement, but that's a good part of the law. At least you're entitled to some response. And we've certainly seen a lot of instances where they drop the ball, they don't get you the response, and they're out of luck on the fees. So let's say that they get the extensions or they don't get the extensions, and you don't have the documents that you need. Again, I think it makes sense to try and keep the lines of communication open for two reasons. One, maybe you get lucky and you can get some kind of rolling production that gets you what you really need first. That's always worth the effort. I mean, let me back up here. This may rub sometimes it rubs me the wrong way. It may rub some of you the wrong way. It's like, well, why the hell do I have to schmooze with these people when the law says I'm entitled to? I mean, you don't have to, but I just think it sometimes works. And so just like when you're working with other sources, it's sometimes works. So that's why I think it should at least be considered. But if nothing works, then here are the steps. You can go to the supervisor. You can petition. I say petition makes it sound like fancier than it is. You can send a letter to the supervisor that says, I've been denied, I haven't gotten any records, or I've gotten some, but I haven't gotten what I think I'm entitled to. And I think I'm entitled to an order from you, supervisor, directing this agency or municipality to give me these records. If you have access to a lawyer, that's great to make some legal arguments. It doesn't have to come from a lawyer. And the people in the supervisor's office do know the public records law. So it's not a waste of time. Don't say, oh, I can't get a lawyer, so I'm not going to bother. It's worth it. It doesn't have to be a fancy letter. If you get the interest of the supervisor, well, they'll rule on it. They have to rule within 10 days, actually, of your appeal. The supervisor can say, I'd like to the agency or municipality, I'd like to see those records. I'd like to examine them in order to determine if they really are exempt. Maybe they should be produced. That can be very helpful. They can, if it's if the town or agency is saying it's attorney-client privilege communications, I don't have to produce them, they can still show them to the supervisor without losing the privilege. But even if they won't do that, they don't have to. If it's privileged, only attorney-client privilege. The supervisor can say, okay, well, you custodian have to produce an index that tells me who it's to, who it's from, general subject matter, and give me enough information so that I can determine if your claim of privilege is actually valid or not. So you can really make some headway with the supervisor. They have the authority, that office has the authority to issue, and again, I'm going to use air quotes, an order granting you relief. The reason I use air quotes is because these orders are not self-enforcing. So the custodian can say, oh, yeah, okay, you say I need to produce it, but I don't think so. I think it's exempt. I'm good. I'm holding. And there's nothing automatic that allows you to enforce the supervisor's orders. But you have two options that can result in enforcing. One, the Attorney General's office has a unit, public records unit, and you can go to the Attorney General's office with your supervisor's ruling in hand and say, hey, I still won't get this. Will you, the Attorney General, bring an enforcement action in Superior Court to make the custodian produce these records. Just having the communication between the AG and the custodian might loosen up some records. So that's often worth it. And they have, in the last couple of years, they've brought a few lawsuits, enforcement actions. I always think it's not a perfect system because, you know, the Attorney General's office, especially with agencies, they represent these agencies, right? The agencies get sued, the AG represents them, and then they got to turn around and sue the agency but it's different people, a different unit. And again, I don't think it's a waste of time. The other option you have is, but you need I suppose you could file a pro se complaint, but usually it would be a lawyer who would file a superior court case asking for an order that the documents be produced. That can be on any number of grounds. You know, the ones that take the longest are the ones where there's some complicated legal issue. You know, there's some confidentiality statute, and does it really apply to these documents? And the judge reads the cases and the statutes, and it takes a while, and the agency appeals. The others that are more straightforward are an agency is just not complying. It's not a tough exemption argument, complicated legal argument. They're just not complying, or they're saying they don't have the resources to do it. Just bringing that action can be helpful. Yeah, you might win it. You might have to fight through and win it. But there's a couple of other good things about it. Sometimes after a lawsuit's filed, the custodian produces the records. That's one scenario. Sometimes they don't produce the records, but you fight and you win the case. In either of those two circumstances, the statute says you're kind of presumptively entitled to your attorney's fees if the supervisor previously ruled in your favor. So that's another reason why, you know, some people say, well, should I go to the supervisor? If I have access to a lawyer, maybe I should just sue. One reason why some people might go to the supervisor is if you get that ruling from the supervisor and the custodian ignores the ruling, and then they either produce the documents after you sue without a court order, or you win, you can get your attorney's fees awarded. And the statute says you know it's presumptively in your favor in those circumstances to get a fee award if the supervisor has ruled in your favor. So that's basically the enforcement mechanism. And why you can see it because part of the reason why I'm an advocate for working the phones with agencies and municipalities is because of the time it takes if you have to go to court to get the records. The supervisor is a relatively quick process. I would encourage people to try that. You know, NEFAC is around. If you don't have access to a lawyer, we'll field questions and try and give you some help along the way. So don't hesitate to do that. But you don't need a lawyer to go to the supervisor, as I said. So I think that's worth thinking about.
We do have one question. I don't know if you want to finish up first, and then we can take the question.
No, let's take the question.
Okay. So this person is asking, when the supervisor of records is allowing an agency to drag its feet, is it better to directly petition the AG or ask the supervisor to petition the AG? For example, I asked for IA records from state police. They produced some redacted records. I appealed. The supervisor told them to give me a response, but it's been over 6 months with no response, and the supervisor has stopped pushing the state police's attorney.
Yeah, I would go to the supervisor and ask them if they will go to the Attorney General on it. If they won't, there's no reason why you can't go to the Attorney General and say, I got this order and I got nothing. I mean, I think an example like that that's pretty appalling, right? They got the order and they're just, they gave you some and they're just done now, I guess, right? They've said, well, we gave you some stuff, we're done. We're on to other things. So I would try both. I would say to the supervisor, they still haven't complied. Would you please go to the Attorney General's office? And, the AG can really, the statute's set up that the supervisor would go, but the AG can do whatever the AG wants to. And if they get an interest in your case, why not? Why not try? The one thing you may run into that's happens a fair amount are exorbitant charges. They're not supposed to be exorbitant, but they can run up, and it's usually if you're asking for big quantities of high volume, where people really do have to search through documents and figure out what's public and what's not. There are some limitations that you should just be aware of in case the agency doesn't do it. And the statute's set up to give municipalities more leeway than an agency. So agencies can't charge you for the first 4 hours of time it takes them to search for, collect, segregate records. This, I hope, goes without saying, but let me say it anyway. It's not unusual to have a document that part of it's public and part of it's not. They just redact or black out maybe there's a juvenile victim's name that's going to get redacted. That doesn't mean they can withhold the whole document, of course. They have to just separate, segregate what's public and what's private, but that can take some time. And so what the statute says is, if an agency needs, and usually be a lawyer to do that, then they have to charge no more than what the lowest paid employee competent to do the job is paid. Just do the math, what their hourly rate turns out to, except for an agency, it can't be more than $25 an hour. And for a municipality, it's a little bit more. No, municipality is still $25 an hour, but they can start charging after 2 hours. The agency has to give you 4 hours of free search and segregation time. There is an option for the agencies to try and get more than $25. And by the way, it doesn't say you get to $25 an hour. The highest they can charge under the statute is $25 an hour. It could be that there's no legal work involved, and the lowest paid employee hourly rate is much less than that, so you can get it for a lower rate. But the highest they can go is 25, unless again they go to the supervisor and say, here's what's unusual about this case. It's really gonna cost more. And I saw one a couple weeks ago where the town said, well, there's a lot of legal issues here. We're going to have to charge $240 an hour to do the search and segregation. And they went to the supervisor and said, supervisor said, no, that's you haven't justified why you would have to charge that much, what private law firm might charge. So again, an example of it's worth it to go to the supervisor with these kinds of issues. Make them your friend too. My worry about you guys in public records laws are that you end up thinking, I'm going to push and push, but unless I have a lawyer, I'm not going to be able to force them to do anything. And I worry about that as one of the problems with the law. But I am here to tell you, first of all, a lawyer's not exactly a panacea, because, oh, great, they file a lawsuit and you're, a year later, you're maybe on appeal, you've won, and they're supposed to expedite them, but they don't always expedite them. So, excuse me. So the going to the supervisor and pushing is really worth it. And I guess this isn't an ad for NEFAC, but NEFAC is a resource that I hope you'll use, because sometimes 5 minutes on the phone can help guide your way through a problem. I'll come back to where I started, which is, think about if you're on the receiving end of a request like this, how you would react to it. I think of it in two ways. One, newspapers sometimes get subpoenas, right? And it's a totally different process, but they're asking for documents. And my mindset then is always, wait a second, that's too much. We shouldn't have to produce anything. That's too much. Or how the hell am I supposed to understand what they mean by that? I'm not going to respond to that. So that's one thing that makes me think about the need to carefully plan the actual request. But the second reason is, this is on Zoom, so I guess you can tell, I'm not a particularly young man. So I know some people over the years who have worked for the government who actually try and comply with the public records law, but get kind of freaked out by the process. I gotta, how can I do this? I don't have the resources to do this. It's going to take me forever to do that. The email search sucks. I can't get a good vendor. The state won't pay for it. So that's another reason why I say, let's work these people and see if we can get some relief with a combination of the supervisor and just what the statute says, which is those agencies and municipalities are supposed to cooperate with you so that you can get what you're looking for.
Well, John, thank you so much for leading this session on appeals. Thank you, everybody in our live audience who joined in, and be sure to check out our other videos on NEFAC's website. So thank you.
Thanks. Bye.